Last week, a realtor called our office with a question that honestly made my stomach drop. He had sellers getting ready to close on a property held in a trust, and they had made a mistake that was probably going to delay the closing, cost everybody money, and possibly kill the entire deal. And here's the scary part. They had absolutely no idea the problem even existed. Hi, I'm Caitlin with Legacy Title Agency, and after handling thousands of real estate closings, I can tell you this is one of the most common mistakes we see when selling property out of a trust. Now, by the end of this video, you're going to know why title companies need trust documents, who actually has the authority to sign, and most importantly, I'm going to show you the one thing you need to do early if you want your trust closing to actually make it to the closing table. Why title companies need trust documents, who actually has authority to sign, and most importantly, I'm going to show you the one thing you need to do early if you want your trust closing to actually make it to the closing table. So here's what happened. A realtor called us and asked, do we really need the trust documents before closing? His client owned a cottage up north in a trust, but nobody could find the paperwork. The seller thought maybe the documents were in a safe, buried in storage, with an old attorney, or maybe sitting in a box somewhere from 20 years ago. And the realtor's thought process was, can't we just deal with this at the closing? Now, this is where things get dangerous, because what most people don't realize is when property is owned by a trust, the trust owns the property, not the individual person. And trusts don't sign documents, humans do, specifically the trustee. So before any closing can happen, the title company has to determine who the trustees are, whether they have authority to sell, and whether more than one person needs to sign. And this is where closings start blowing up. Now, before we go further, let's quickly explain why people even put property into trusts in the first place, because this part actually matters. In Michigan, when someone dies owning property in their individual name, the family may have to go through probate court before the property can legally be sold. And probate court can mean court filings, delays, attorney's fees, paperwork, hearings, and waiting months before anyone has the authority to act. So most people want to avoid that entire mess. Instead, they transfer the property into a trust. Now the trust owns the property. And because a trust doesn't die the same way a person does, control can pass down instead from trustee to trustee without opening up a probate estate. Sounds great, right? Well, only if everybody can actually prove who the trustees are. And that's why title companies need trust documentation. Because the trust itself contains the rules. It tells us who can sign, who controls the property, whether co-trustees exist, whether somebody may have passed away, and whether additional approvals might be required. Now, here's the part that makes my stomach turn. People love waiting until the last minute to look at these documents. And after thousands of closings, I can tell you something very important. People do not always remember what their trust says. In fact, it's extremely common for someone to think, I'm the trustee, only for them to open that trust document and discover there are actually two trustees required to sign. And suddenly the seller's sister is vacationing in Florida, or somebody hasn't spoken to another trustee in 5 years. Or one trustee never even knew the property was being sold. And now everybody's sitting at the closing table wondering why the deal just exploded. This happens all the time. That's why we always want trust documents reviewed as early as possible, because discovering problems 3 weeks before closing is manageable. Discovering them at the closing table, that's when you get a disaster. Now, thankfully in Michigan, we do have some options. Obviously, the easiest solution is if the seller already has a current copy of the trust. But realistically, a lot of these trusts were drafted 10 years ago, 20 years ago, sometimes even longer. So if the documents can't be found, one great option is contacting the attorney who originally prepared the trust. Many times they still have a copy. But here's the pro tip most people don't know. Michigan law also allows us to rely on something called a certificate of trust. And this can be an absolute lifesaver. A certificate of trust is basically a simplified summary of the important trust information. It can confirm if the trust exists, who the trustees are, who has signing authority, and what powers they have, without needing to hand over the entire giant trust document. And in many situations, it can save everybody time, stress, and a massive closing delay. But here's the key. You still need to deal with this early, because waiting until the week of closing to start hunting for trust paperwork is one of the fastest ways to delay a transaction. If you're selling property out of a trust, gather those documents immediately. Not later, not after inspections, not the week of closing, immediately. Because trust sales can be incredibly smooth, or they can turn into absolute chaos if nobody verifies authority up front. Here's another trust closing problem that catches people completely off guard. And honestly, this one creates panic on closing day all the time. A lot of people assume that when the property sells, we can just wire the money directly into the trustee's personal bank account. But depending on the situation, especially after someone has passed away, the trust may actually need its own bank account set up in the name of the trust itself, not the trustee personally, the trust. And if nobody prepares for that ahead of time, suddenly closing day turns into, wait, where are we even sending the money? Now everybody's scrambling, calling banks, trying to open accounts last minute, hunting down trust paperwork, all while the buyer, agents, and lender are waiting for the deal to fund. So if you're selling property out of a trust, one of the best things you can do early is talk with your attorney, accountant, or bank and make sure the trust has the proper bank account ready before the closing day. Because nobody wants to successfully sell their property and then realize they have nowhere to deposit the proceeds. And remember, this video is general educational information only and is not legal advice. Always consult with an attorney regarding your specific situation. If you're buying, selling, or investing in real estate anywhere in Michigan and want to avoid costly closing mistakes, make sure to choose Legacy Title and subscribe to the Legacy Closings YouTube channel. And we'll see you in the next video.